Okay, good morning, everybody. Welcome to this morning's session of the UK-China Tech Forum. Today's session is focused on China's personal data protection law and implications for your business. So as many of you may be aware, the CBBC partners with Tech UK on the UK-China Tech Forum. And we typically organise an event, around about one event each quarter, focused on opportunities for UK and Chinese tech companies to collaborate and do business together. Today's session is in partnership with with DCMS, the Department for Digital Culture, Media and Sport. And we have Hugo Ridley from DCMS will speak at the end of this session to introduce a little bit more about the support that DCMS is providing for tech and digital companies looking to do business with China. So the session, it's obviously a very topical subject, the data laws in China, whether you're based in the UK dealing with GDPR or trying to tackle the issues, the new legislation that's come into play in China in recent months. There will no doubt be more developments in this area. So today's a great opportunity to learn from some experts about what's happening in China and how you can prepare your business to overcome some of these regulatory hurdles. So just a little bit of housekeeping to start with. We are recording this session, so just to be aware that we're doing that. There will be an opportunity to ask questions as we go through the session. So please use the Q&A box, the chat box, to ask any questions that you have. We will have around about 10 minutes for Q&A at the end of, or I should say midway through the session after the main speakers have spoken. So if you have any burning questions as we go through, just feel free to fire them into the chat box and we'll address them that way. I don't think I have any other housekeeping points to raise. Just in terms of the agenda, I will hand over in a moment to CBBC's policy analyst in Beijing, Joe Cash. We'll then go on to an overview of China's cybersecurity and data protection landscape. And we're very fortunate to have Anthony Myers, who's the head of digital and cyber at the British Embassy, who will cover that wider landscape piece. We've invited James Gong, who's a partner with Bird & Bird, the legal firm, to talk in a bit more detail about the personal information protection law and go into a bit more granular detail on that. We then have some time for Q&A, and we'll wrap up with Hugo from DCMS, who's going to talk a little bit more about the DCMS microsite. So without further ado, I will hand across to my colleague in Beijing, Joe, and I'm going to hope that all the technology works and we have no Zoom gremlins today. So over to you, Joe.
Thanks, Mark. Good morning, everybody in the UK. Good afternoon if you're joining from China. My name is Joe Cash. I'm the CBBC's policy analyst. I'm based in Beijing, leading our policy and research work. And the personal information protection law is it's an area that I've been asked a lot about over the last couple of weeks. So it's great that we're having today's session and that we've been joined by Anthony and James. So the PIPL, it's been in our lives for just over a year now. The first draft was published last October, passed into law in August, came into effect in November. And it's a big change. It's similar in many ways to the EU's GDPR, that if you're a business in the UK or if you're a British business in China, you're already probably very familiar with. But there are a few very distinct differences. For a start, China's legal framework is driven more by security concerns rather than consumer rights. And it has already, if you've been keeping up with the news, caused a slight degree of mayhem. China is no longer giving out the information of Chinese ships in the local area, which is kind of exacerbated issues already with global shipping. So it's a complicated piece of law that China is getting its heads around and businesses are getting their heads around. And it's important to get it right. Get it wrong, you could be looking at a fine of £5.6 million or 5% of a company's turnover in the preceding year. So it's important that we're paying attention, and that's why it's great that we have James from Bird & Bird to give his overview of kind of how companies should be compliant with it. A bit on Chinese consumers, when we did some research on the PIPL for CBBC's Focus website, which I will direct you all to, we have some great content there, not only on China's cyberspace environment, but on all new pieces of legislation, what's going on in political affairs, UK-China relations. We discovered that in a 2018 survey by the China Consumer Association, 85% of Chinese online users had experienced some form of data leak, while 95% of respondents were taking precautions when sharing their personal information. So this is a market where its consumers are very hot on it. According to the UN, they have the same level of concern as the stereotypically kind of concerned Germans. So that's the background to the law. Now handing over to Anthony, he's going to provide us more of a background information into China's cyber security landscape. Anthony has been working as First Secretary in the British Embassy in Beijing, covering AI, digital data and cyber policy since October 2019, and also has oversight of the UK Embassy's science and innovation work in Beijing and Northern China. His career has mostly focused on cyber issues and was previously head of the Foreign and Security Policy team in the British Embassy in Rome when he was seconded to the Italian MFA for the Italian 2018 chairmanship of the Organization for Security and Cooperation in Europe, where he focused on digital and cyber issues. So I can't think of anyone better to introduce the cybersecurity landscape. Anthony, over to you.
Thank you. Thanks for that introduction and for the invitation to speak today. Hopefully I'm just going to give you some of the wider context and the background to the new data laws and data regulation. And I think sort of James is going to go into a bit more kind of, sort of technical and legal detail. I don't think you needed to have been in China in recent months to know that a lot has happened. And so data and the new data laws and data regulations are just one part of a bigger picture, albeit a pretty big and important part. But I think to kind of understand what the drivers are of these new laws and regulations, and to make an educated guess at what might happen next or what the end game might be, we need to briefly consider the wider context. So for about a year, it was roughly this time last year, when the news about the non-IPO of Ant Financial, part of Alibaba, came through. Since then, we've seen an increasing pace and scope of regulatory developments in China. And that has included specific action against some of China's biggest and most successful internet companies and online platforms in a range of sectors, and including high-profile cases involving Ant Financial, which I just mentioned, as well as the ride-hailing service Didi and the food delivery platform Meituan. This has sort of variably been coined or termed as a crackdown or a clampdown, in particular on China's tech sector. And that is in contrast to what was previously relatively light touch regulation that allowed internet companies to grow and to globalize, often through quite aggressive competition. This all raises issues across multiple sectors, as well as impacting on investors, on market access issues, and kind of business environment and compliance issues. I think in this period, let's call it a crackdown. In the crackdown, we've seen different themes and different drivers and different objectives. There's quite a few of them. Lots of them are overlapping, and the whole thing, especially kind of earlier on in the summer, it's been quite uncoordinated between different parts of the Chinese system. Some of the kind of key themes and objectives are as follows. So there's been a particular focus on antitrust and sort of greater use of the Chinese anti-monopoly law. And I think that's about quite a few issues. So it's about financial and economic stability. It's about economic fairness and inequality. It's in part about data monopolies and so on. And kind of that strand of recent developments is led by the relatively new States Administration for Market Regulation, SAMR. A second theme which I wanted to highlight was around financial stability, consumer debt, and what the Chinese talk about as the disorderly expansion of capital. So the case involving Ant Financial is perhaps a good illustration of that. And those issues are mostly led by the People's Bank of China, the PBOC, as the key regulator. Another theme is around common prosperity. President Xi and the Chinese government have talked a lot about common prosperity in the past few months, and that's very much linked to sort of inequality and fair competition again. As we know, and as we'll get onto in a second, data is another theme, sort of data regulation, data security, personal data protection, and so on. And that has mostly been led by the Cyber Administration of China, the CAC, as the key regulator. There are possibly many other themes that I could mention, but hopefully that gives you a picture of a kind of a spectrum and range of issues and drivers, as well as kind of different regulatory authorities or bodies within the Chinese system. Whilst sort of 2021 and particularly the past few months has been particularly active and busy, and I think we've all been surprised by the pace and the scope of the development. Most of what has happened hasn't come out of the blue. So there have been sort of signals and policy signals and messages from the Chinese leadership for some time. So for example, in 2019, the State Council flagged its intention to more fully regulate the internet sector. And back in 2019, it had already started to revise the rules for online commerce, for example. And over recent years, but particularly since the start of, since the outbreak of COVID-19, President Xi has also increasingly emphasized the importance of the real economy over the online economy. And last year, I think it was, he also set out his dual circulation strategy, which is kind of, also relevant to that issue of real economy versus online economy. Lastly, as I'm sure you all know, we're in the year of new 5-year plans. So the Chinese government published the 14th 5-year plan, the overarching national one, earlier this year. But under the framework of the 14th 5-year plan, every part of the Chinese system and every sort of province and local government and so on all develop and publish 5-year plans for their sector or their area. So in August this year, the Chinese government issued a 5-year blueprint, a 5-year plan aimed at reshaping China's tech industry, for example. So between that plan and various other things, it is likely that this kind of regulatory action is going to continue far into next year and possibly beyond. So that's kind of some of the broader context and background. For the next bit of my presentation, I'm going to focus in on data and cyber regulation. So I think the key, one of the key points to make is that there is growing recognition within the Chinese government and the Chinese system that data is both a vital economic resource as well as a core issue of national security. So back in April 2020, the State Council announced that alongside land, labor, capital, and technology, that data was the fifth factor of production or driver of economic growth. So that was a kind of important milestone for really putting data on the map, so to speak. Then sort of fast forward a year, Chinese 14th 5-year plan further set out measures to promote the use of data,
We seem to have lost Anthony. So James, perhaps we can turn to you now. Now that we've kind of got an idea of where the personal information protection law has come from and how China's cybersecurity landscape has evolved, particularly since the introduction of a cybersecurity law, what do companies need to know in order to be compliant with it? And I'll briefly read out your bio so that those online know a bit more about your background. James Gong is a partner in Bird & Bird's Beijing office, focusing on supporting clients in the technology and communications space. He has extensive experience in advising on cross-border mergers and acquisitions and general corporate and foreign direct investment issues, having represented clients in a broad range of industries and specializing in technology, media, telecommunications, cybersecurity, and data protection. So James, over to you to let us know on what we all need to be paying attention to in order to be compliant with the PIPL. Thanks.
Thank you, Joe. Just let me share my screen with the audience. Okay. Can you see my screen? Yes?
Yeah, that's come through nicely.
Okay, thank you. All right, just let me do the slideshow. Yeah, all right. Okay, so yeah, I'll just for today's session, I'm gonna give the audience a brief overview of the PIPL and also the Chinese data regulatory regime. So on this page, you will see three laws or three pillars that that form the data protection regime in China. So the PIPL is not the only law that will regulate the data protection in China. From left to right, you can see the cybersecurity law, which took effect in June 2017, the data security law, which took effect on the 1st of September, and also, of course, the PIPL, which took effect on the 1st of November. So you see that the regulatory the regulatory journey starts with the cybersecurity law back in 2017, and it take another 4 years until this year when the authorities started to sort of accelerate their regulation of data, and the two milestone legislations were enacted this year. Namely the data security law, or the DSL, and the PIPL. And as Joe just said, that the PIPL has imposed a hefty fine of up to 5% of annual turnover, or a renminbi of 50 million. So that's in a sense even that's even more even severer compared to the fine under the GDPR and the Data Protection Act of the UK. And on this page, we'll briefly talk about the relationship between the three laws. So for the CSL, which stands for the cybersecurity law, and DSL, there's overlap because both laws will concern the security side of data, but the CSL concerns more about the security of the information systems in China. So if you have a information system or information infrastructure located in China, then it will be the security of the system will be subject to the CSL, whilst the DSL will concern more about the security of the data. So it also, of course, covers the security of the information system, but it also imposes obligations to protect the data generally on those who process data in China. And more importantly, the DSL creates two categories of data that must be protected in China. And these two categories are the important data and the core data. So these two types of data are considered significant or relevant to the national, sort of state security, to the national interest, or to the public interest. And in terms of importance, the core data will be even more important than the important data. But on the other hand, the PIPL also will have an overlap with the DSL and the CSL, because for certain personal information, well, if it could be considered important data. For instance, if you process personal information of over 1 million individuals in China, then such amount of personal information might be considered important data, and as a result, needs to be stored in China. So that's the overlap between PIPL and DSL. And on the other hand, the CSL and the PIPL will also have an overlap, because the PIPL also requires the data processors to take technological measures to protect the personal information. And therefore, to comply with the PIPL, you should also be mindful of the CSL, because you have to comply with this requirement on the CSL in order to protect the information system, which will also process personal information. But of course, the PIPL will, the focus of the PIPL will be on protecting the rights and interests of the individuals to their personal information. And on the right, you will see the relationship between the different types of data. So we have the personal information, and within it, for the personal information that is more, that will have a greater impact on the individuals if it is illegally disclosed, and you will be considered sensitive personal information. And we have to note that for sensitive personal information, scope is larger than that of special categories of personal information under the GDPR. And for important data and the core data, then the important data will, in a way, overlap with personal information, as I just said, that for large amount of personal information, perhaps it will also be considered important data. And currently in the draft regulation, the threshold is about 1 million individuals. And of course, we all know there's also special category called the state secret. The state secret is a separate scope. It's a separate category. It is the most important information. That is the type of data that must be protected at the level that is even higher than that of the core data. So it's at the top of the pyramid. So nowadays in China, there's also a regime called the grading and classification regime of data. So generally speaking, all the data will need to be put into different levels in accordance with its importance. So far, there are 3 levels from top down. The 3 levels are the core data, the important data, and also the ordinary data. And these 3 levels could have an overlap with sensitive information. So generally speaking, most of with the personal information. So if so, the personal information could be considered ordinary data. If you have a large amount, it could also be considered important data. But at the moment, we don't know what will be considered core data, and there's no guidance. Hopefully, there will be some new regulations that will be released on that. In terms of, and on this page, in terms of the scope of the PIPL, so we usually will focus on the territorial scope of the PIPL. The reason is that for the PIPL, it will cover not only the processing activities within China, it will also, but also cover the processing activities relevant to Chinese residents' personal information outside of China. So if, for instance, if you are processing personal information of Chinese residents in the UK for the purposes of providing products or services to them, and for example, if you are running e-commerce website to sell your products to them, or if you are you are a mobile app developer that runs an app and provides services to Chinese residents, then your processing activities in the UK will be subject to the PIPL. And also, if you process Chinese residents' personal information for analyzing, evaluating their behaviors, then you could also be subject to the PIPL. So in that circumstances, you might need to consider, whether your processing activities will be subject to the PIPL. For instance, if you sell some IoT devices to China, or if any sort of devices that could collect, wearable devices that could collect personal information like the health information of a person, then you could be subject to the PIPL. So in that case, what actions do you need to do? So we would suggest that you take about 4 actions. And firstly, you need to identify which entities will need to comply with the PIPL. And once you have identified the entity, you must update the client-facing privacy policies and consent forms, because these are the important documents that your customers will be able to read, and they could easily tell whether your documents comply with the PIPL. And third is that you must appoint a subsidiary or an individual in China to deal with data protection affairs, and this is a mandatory requirement under the PIPL, because the authorities would want a foreign entity to appoint someone in China that they can directly liaison with for data protection matters, and this is also a requirement that is similar to the GDPR. And lastly, but not least, you must take required technical and organizational measures to protect the personal information. And I mean, these are the minimum actions you must take. But of course, there are, as the PIPL will apply directly to your company, it means that you must comply with all the requirements on the PIPL. And another topics that I think worth discussing is the legal basis for processing. I think that is where the GDPR and the PIPL are quite similar. So on the both laws, you cannot process personal information unless the process is based on certain lawful grounds. And both the GDPR and the PIPL have provided certain lawful grounds or legal basis for processing. And if you look at this table, you would know that there are differences between the two regimes, in that the legitimate interests is not recognized as legal basis for processing. And for those who have experiences in dealing with data protection issues, legal interests is very popular, or most welcome sort of legal basis across Europe when it comes to data processing, because this will give the clients, the data controllers or processors, a way to avoid using consent as a legal base, because the consent, when you're using consent as legal base, it means that you have to meet all the very high requirements for consent, and the data processors can withdraw their consent, which means that you have to stop processing their personal information. But on the PIPL, there's no such legal basis, which means that you have to find a lawful basis for the data processing activities that you previously conduct relying on legitimate interests. So this is something that you must pay attention to when it comes to compliance with the PIPL. And speaking of consent, the consent under the PIPL, there are three major requirements for a valid consent, namely the individuals must be fully informed, the consent must be freely given, and it has to be unambiguous. And compared to the GDPR requirements, you perhaps would notice that there's no requirement specific. So the consent does not have to be specific in all circumstances. So in a sense, it means that the consent can be bundled. So that's perhaps the advantage of using consent as a lawful basis under the Chinese PIPL, because for the GDPR, the consent has to be specific for a processing activity for certain purpose. But in China, you can have one consent for processing activities for multiple purposes. However, having said that the law does require that separate consent is required. It does require that separate consent must be obtained in certain circumstances. And here, the separate consent means that the consent has to be specific and cannot be bundled with other types, other consent. So these circumstances will include providing personal information to another personal information processor, processing sensitive personal information, providing, deploying image capturing, or identifying devices for purposes other than public security, disclosing personal information to the public, and also exporting personal information outside of mainland China. And just here I have to make it clear that when we say personal information processor, it is actually a term that is defined under the PIPL. So on the PIPL, personal information processor means someone that can determine the means or the purpose of the processing. So this is the equivalent concept of data controller under the GDPR. So when we say personal information processor, it should be interpreted as the controller, the data controller under the GDPR. So just to make it clear. So sometimes you get confused as to whether this will be the personal information will be will actually mean the data processor on the GDPR, because under the GDPR, the data processor means the entity that actually processes personal information on behalf of the controller. But in China, there's no such concept. So in China, the data processor equivalent is the so-called entrusted processor. So we'll get to that point later. A new consent is also required when there are changes to your processing activities. Notification requirements, you may be familiar about that. So basically it means that you have to tell the individuals how you're gonna process their personal information, any details of processing, and this would at a minimum include name and contacts, purpose, means of processing, types of personal information, etc. So these are the other contents of notification. And notification will apply, in most circumstances, irrespective of which legal basis you rely on, you must notify the individuals unless it is just not possible to do so. For instance, in an emergency, you need to protect the life of the individuals, and then you have to notify them. Or if in certain circumstances that is for law enforcement, then you cannot notify the individuals. Otherwise, you just need to notify the individuals of the processing activities. So as a result, we would recommend that you update your privacy policy notice and also to design a consent form to obtain their consent, because you cannot rely on consent as the legal basis, and as a result, the consent is usually a substitute for legitimate interest under the PIPL. And also, when you obtain the consent, you might need to think about how to design that, whether through the checkboxes, the consent forms, or pop-up windows. And here we'll also talk about the cross-border transfer and the data localization, which is a very hot topic. So now we have two draft regulations. One is the measures for security assessment for data export, and the other is the draft regulations. Yeah.
Apologies. I just wanted to just interrupt you for a second, because I think we probably I know you've got a few slides left, but we've probably got about 5 minutes before we need to kind of move on. So if you want to kind of just cover off those slides that are sort of key, I guess, for the next 5 minutes.
Yeah.
And then we've got lots of questions coming in as well, so we'll then shortly move on to the Q&A.
Yeah. Sure. Yeah. All right. So so for the two laws, we have a security assessment regime that will be established for certain transfer. So generally speaking, if you this diagram shows the flow chart for conducting the data export process. So first you decide whether you are CII, and if you have important data, or if you are exporting the personal information outside of China, and if that is the case, you need to go through a self-assessment. And if you satisfy the self-assessment, then you must decide whether you meet the thresholds to qualify for the government assessment. If you pass the governmental assessment, then you'll be able to transfer. The governmental assessment will take up to 60 working days. So it is something that will give you a bit of uncertainty when it comes to transferring data outside of China. And this is something that you all need to consider if you receive personal information from China or transfer it outside of China. And on this slides, it's just the illustration of the government assessment process. So there will be an application being filed to the provincial CAC, which will then hand it over to we'll pass it on to the CAC at central level, and the central CAC will decide whether to accept it, and will then review it. The decision, the approval is valid for 2 years. So that means that you will need to apply for a new assessment in 2 years' time. Generally speaking, we would recommend that you conduct China-focused data mapping and be prepared to sign a standard contract, because this is something similar to the SCC. And also, if you meet the data localization requirement, perhaps you need to be prepared for that to localize your personal information. For third-party processing, there are 3 types. One is joint processor, which is the same, which is similar to the joint controller relationship, where both parties will determine the purpose and means of processing jointly. The entrusted processor is akin to the controller processor relationship, where the entrusted party cannot determine the means or the purpose of processing, will only process personal information on the instruction of the processor. And then we also have the sharing or providing of personal information to third parties, as PIPL put it. So this is like the independent or the controller relationship under the GDPR. And and because of that, any change to the purpose or means will require new consent, and also for that transfer, a separate consent will be required from the individuals. The individual, and on this page, the individuals also have certain rights, similar to the GDPR, and you must be able to enable the individuals to exercise their rights and respond to their requests to exercise the right. Otherwise, they will be able to seek civil remedies at the court.
Okay. Sorry, can I quickly butt in with a question just on that point? So, for example, if you are an organization and you have an email-based form online that requires people to input their email address to find out more information, if you were, say, to include a disclaimer that clearly explained why said information was being collected and the individual of that organization's name, would that then make that email form compliant? And then if I'm running a UK-based organization, but I have a wholly owned subsidiary company operating in Beijing, would it be appropriate to appoint an employee working in that subsidiary as that contact person for that email submission form?
Well, so you are processing personal information of Chinese residents here in the UK, right? And that processing is for the purposes of providing certain services to the Chinese residents. And in that case, then the PIPL will apply directly to your processing activities here in the UK. And in that case, then you can appoint an employee in China as the representative, or you can also appoint the subsidiary as the your representative back in China, if that is your subsidiary in China. So that representative can be your subsidiary or an individual. So both ways will meet the PIPL requirement.
Thanks. And I'll just read out one other question that's related, and then perhaps we can return to Anthony to just continue the update from government on this piece of legislation. Has the CAC released its standard contractual clauses template for data transfer yet? And if not, what do you advise an organization to do?
Well, it has not. So in that case, in most cases, we cannot have a standard contract. So, so for the multinational clients, we would suggest that either they use their current international transferred contracts or terms, or if they want, we can sort of amend their current terms to add certain clauses to cover the PIPL, just to, for instance, we can say in the terms that once the standard terms comes out, they will need to enter into the new contracts, or they will need to give some warranties or representations as to their ability to protect the personal information and meet the requirements of the PIPL and things like that. Because there's no standard contracts, so we won't be able to set it at this point.
Thanks. And this is clearly a piece of legislation that companies are going to have to, well, both the companies and the government are going to be getting their heads around over the coming months into the coming year. Thanks, James. Are you happy to share your slides with the panelists? I know there were a few more on guidance towards compliance. Is that okay if we share the slides after today's session?
Yes, sure.
Brilliant. And Anthony, you seem to be back.
Boosted off, he knows why. Let me just kind of take 60 seconds to finish off what I was planning to say. 3 broad points. Firstly, on the context in which all of this is happening. The point which I think I started to make earlier was that while there's growing recognition in the Chinese government, the Chinese system, that data is a vital economic resource, there still remains a focus on the national security aspects of data regulation and data law. So, and I think that can be clearly seen in the three kind of cornerstone pieces of legislation that James has just been talking about. But it's kind of worth bearing that in mind when thinking about engaging with the Chinese government on any of these issues. Another point to note, final point on kind of, sort of context, the things which are rightly kind of grabbing focus and attention is PIPL and the other laws, but there's lots of different developments in this space. So, for example, both Shenzhen and Shanghai in recent months have published their own data regulations. There's been national regulations on facial recognition and on algorithms, and there's been data security measures specifically for the automotive sector, for example. So, and it's not clear to me, at least, how all those kind of interact with each other. So if you're in automotive sector operating in Shanghai, what bit of regulation or law has primacy? But yeah, another thing just to kind of think about. My second point is longer term outlook for this regulation, particularly in the data space. It feels after the passing of the data security law and the PIPL law that we're past the peak of this regulatory action, and there's now some sort of degree of certainty that there wasn't before because we have this legislative framework. But as James was discussing and pointing to, there's a lot of detail that needs to be worked through, all the different definitions, what is important data, and so on. And yeah, there's a lot of the detail of the implementation and enforcement that has to be worked through. And if we look back to the cybersecurity law, which came into force in 2017, only in recent months, 3-4 years later, have we got some of the final measures under the cybersecurity law. So it could be some time until all the pieces of the puzzle are in place. Finally, just to kind of very briefly mention what the UK government is doing on all of this, particularly at the embassy here in China. So firstly, we kind of recognise the increasingly complex regulatory and business environment here in China, and we know that has real implications for UK businesses and wider stakeholders operating in China. So we raise these issues in our engagement with the Chinese government, in particular the Cyber Administration, which is responsible for lots of the laws and regulations in the space, but other ministries such as the Ministry for Industry and IT, and so on. The embassy also responds to the public consultations from the Chinese authorities on the laws and kind of regulations. So, and we work closely with the CBBC and others on that to submit a consolidated response that captures all the kind of UK interests and concerns. As I'm sure many of you know and are familiar with, we have a large team from the Department for International Trade in a number of sectors, including the tech sector. So, they're here to support UK businesses doing trade and investment work in and with China. And then very finally, sort of early in 2022, where the embassy is looking to hold a data roundtable to kind of explore lots of these issues. We hope to have this government there. It's not in our gift, and it's not always possible. But the intention is to have the Chinese government there, so we can put some of these kind of questions and concerns to them. I'll stop there. Thank you.
Brilliant. Thanks, Anthony. Good to have you back. And so if I'm a British business and I'm trying to find out more information from the UK government, am I right in thinking that Hugo Ridley, who is also on the line, has the website for me? Hugo, are you there?
Thanks, Joe. You're right in thinking that. I've had a few technical glitches, so hopefully you can all hear me. Yeah, I work as the head of the China team at DCMS, where my colleagues and I focus on creating a healthy UK digital economy in a fast evolving global environment in which China is obviously a key actor. So I very much focus on the digital of DCMS. But yeah, I wanted to take this opportunity to make a quick plug for the government's China Digital and Tech website, which was launched at the end of last year with a lot of surrounding comms to help UK tech firms, but particularly SMEs, engage safely and ethically with China, with guidance on managing ethical, legal and commercial challenges when working in China or with Chinese companies. And both CBBC and Tech UK very much supported us on this initiative. The website contains a host of information about UK and Chinese law relating to the digital and tech sector, advice from the National Cyber Security Centre, the NCSC, and Centre for Protection of National Infrastructure, CPNI, including tools to empower startups and investors to foster a healthy security culture from the outset and continue to protect vital company assets as businesses scale and collaboration opens up overseas opportunities. The website also includes steps to protect IP and kind of contacts for our IP attaches in post. And finally, it includes real-world examples of where tech companies have been able to successfully navigate challenges to take advantage of the opportunities from the Chinese market. So please do check it out and spread amongst your networks if you haven't already. We aim to update the website factually on a quarterly basis. Obviously, as we've spoken about today, there's a lot going on when it comes to regulation of the digital sphere in China lately. We haven't yet updated with the very latest on PIPL and the data security law, which were in draft at the time of the last update, but we will be doing so shortly. So please do look out for that advice when it goes up. Thanks everyone, and thanks Mark. Back to Joe, I think.
Brilliant, thanks Hugo. And the link to that website should have been posted into the chat box for your reference. So we started slightly late, so we can carry on for 5 minutes or so for Q&A. But I understand if you have to drop off the call now because you have other commitments. One plug from CBBC, do check out our Focus news site. We have policy updates on the PIPL, China's cybersecurity environment, and a whole podcast episode on its introduction, drafting, and what it might mean for your business. So we've had a few more questions in the chat box over the last few presentations. And I suppose the first question, this is one for Anthony and Hugo. Do we have any assessment of the net economic impact of these laws and the tightening up of China's cybersecurity environment in general towards the UK tech sector?
I was holding back to see if Hugo was going to jump in and answer that quite difficult question. I think the short answer is no, not yet. It's relatively kind of early days, particularly kind of for the new laws. But obviously, as we've discussed, we're aware that it has significant impact in terms of market access and business environment and compliance costs and risks for UK businesses in China. And we're working closely with CBBC, Tech UK, and others to kind of raise that with the Chinese government and find solutions or ways to kind of mitigate the worst bits of the impact. But yeah, in terms of like a more sort of global assessment.
We seem to have lost Anthony again, but no worry. And James, one question for you that I was asked earlier this week: is there a minimum age for collecting a person's personal information for a CRM within the PIPL?
Well, there's no, I wouldn't say a restriction, but if you do collect personal information of a child under the age of 14, then you will need to obtain the consent of his or her guardians in order to process this child's personal information. And since the child's personal information is also considered sensitive personal information, so you might need to comply with some extra requirements for processing sensitive personal information. For instance, you will need to conduct impact assessment for the processing. And in addition to that, before the PIPL, there was a regulation on processing the personal information of children online. And under that, you might need to also include a special policy for privacy policy for processing of their personal information, and maybe also a special contract for processing for the children when you offer services to them. So that's the requirement for children's personal information. You're on mute.
Thanks, James. You've made my tomorrow far easier, as I now know the answer to that question. And we have one more question in the box that I knew you were typing an answer to, but my parent UK company already owns its wholly owned foreign enterprise, and the legal representative in China is Chinese already. Do we need to appoint anyone else?
Well, actually, you can appoint your legal representative in China. And you can also employ an employee of your local subsidiary, or you could perhaps appoint anyone who's willing to take that role. So far, the PIPL has not laid down any restrictions on who can be appointed as your local representative. So long as the person is capable of dealing with the matters and is located in China, then that should suffice.
Brilliant. Thanks, James. And I'm conscious that we're coming to time. So what's the best way of attendees contacting you if they have any further questions?
Yeah, sure.
So what's the best way? Should I email you or? No?
Well, yeah, of course. You can email me. And I think that will be easier. Or if you and the audience can also email me directly if they like. Either way is okay.
Brilliant, thanks, James. And we'll be sure to share your email round with the attendees after today's event. James, Anthony, Hugo, thank you for joining us for today's discussion. It's been very informative, and I hope that those online feel more comfortable, confident in how their business can be compliant with the PIPL going forward. Do keep your eyes on our WeChat if you're in China, or our website if you're in the UK, to see our future upcoming events. You're very welcome. And if you're looking to get the latest on China's regulatory affairs, As I said before, please check out Focus and take a listen to our podcast for China Business Brief. We hope to keep you thoroughly updated there. I hope you have a good day, good evening if you're in Beijing. Bye-bye.
Thank you very much. Goodbye.